Semifinals, we want to do a roll call to all the teams progressing to semifinals, beginning with FIL, TL, FTI. Are you guys complete?
Here.
FTSP1, are you guys complete?
Complete.
FSRD1, are you guys complete?
Yeah, we're here.
FKG1, are you guys complete?
Yes, we're complete.
FK2, are you guys complete?
Complete.
FEB, FTSP, are you guys complete? FEB, FTSP, are you guys complete?
Yes, we're here.
FILTL1, are you guys complete?
Complete.
FH3, are you guys complete?
Complete.
Okay, so I think let's take another photo session to get the documentation for the semifinalists. IT team and Humas will help. So I'll pass on to Mas Adit. Thank you, Mas Adit.
Oke, mohon izin untuk slide 1 untuk menyalakan kameranya masing-masing. Mohon izin untuk menyalakan kamera di slide 1 untuk melakukan sesi foto bersama. Untuk pelari, Samuel, Jessica. Oke, baik, kita mulai ya di slide pertama. 3, 2, 1. Oke, sekali lagi. 3, 2, 1. Next, slide berikutnya. 3, 2, 1. Sekali lagi. 3, 2, 1. Oke, terima kasih semuanya.
Okay, we thank the IT Humas team for helping with documentation. We have 7 minutes until I pass for motion launch to for adjudicator Ibu Astri. Oh, sorry. We're gonna release the draw at 12:40. My mistake, sorry. We're gonna release the draw at 12:40 until 12:50. And at 12:50, the motion launch will be announced by court adjudicator. So yeah, for the time being, please remain here. And if you want to chat in the main room or converse with anyone here, you may. Okay, so we've reached 12:40 p.m. waktu Indonesia Barat. The draw has been released. So let me share you the screen. 1 second. So draw for semifinals, here it is. In room HE, we have FHL-TL-FTI as opening government. We have FH3 as opening opposition. We have FKG1 as closing government. And lastly, we have FK2 as closing opposition. In room HH, we have opening government FTSP1. We have opening opposition FSRD1. We have closing government FEB FTSP. And we have closing opposition FALTL1. So the matchup is pretty clear. Please use this following format. Just the rooms. Rooms, role, team name, name. And please wait for a few minutes. We will assign you manually to your rooms. Okay, so I'll pass on to CA, for the time being, to Bu Asti.
Fifth, remind everyone to change their name and please check.
Okay. Everyone, please make sure that you have renamed yourself. You don't need to include round anymore. You just have to
I
use
see
the
Rain
format.
still hasn't changed.
Okay, Rain, please change your name with the format, rooms, role, team name, and name.
Judges.
Boleh, can you show the draw again?
Open tabby cat. Oh my god.
Baru kelar makan nggak? Bentar.
Hey.
HE.
Oh yeah, please also let your friends, your lecturers, your vice dean, and your dean, let them know of the live streams. We're gonna use the live streams for the semifinal. There will be 2 different live streams for 2 different rooms. If you have received the information, so please forward it so make sure that we can amass a number of audiences. So I think that is all. Thank you.
Okay. I know the music was not as apparent as the previous round, but the music was actually the clue of our next heading. Hold on a second. There you go. Okay, so just to check now, is it the correct possibility? Are you guys seeing a blank white PPT with those NUDC Trisakti poster?
Yes, ma'am.
Okie-doke. So
Yes.
okay, so before we start with the PPT, I would like to first explain that there are several rooms where the adjudicator are in odd number and some in even number. Reason being is because we only have 5 adjudicators, but worry not. In the process of adjudication in BP, when there is paneling, we have what is called as deliberation. What does it mean? Deliberation is the discussion between all the panel of adjudicators. So it's it doesn't matter odd or even because we are not voting. So they will going to discuss and create a unanimous decision on who gets the rank. But yes, I'm fully aware that there is a possibility that the discussion does not come to a consensus. In an even number room, when there is a voting, the chair will going to have 2 votes. So that's a little bit of an explanation. Onto the reason why the assignation of adjudicators are only 2 in one room and in another are 3 is simply because that the other room, considering the ranking and also the score, are pretty tight together. So it's a tighter room. It requires, an odd number of adjudicator. Just to clarify, specifically because most people here are not that familiar with debates. Now, moving on to the motion. For the semifinal, under the heading of law, the motion reads, so this is now 12:46, so the debate will start at 1:02. The debate will start at 1:02. The motion reads, this House prefers trials where victims and defendants are anonymous. Is there any question about the motion? Going once? Going twice?
I have a question.
Okay.
So, usually like in trials where there's like cross hearing and stuff, so will the defendants and victims not be present in the trial, or they'll be in separate rooms, or like?
It is up to the opening government on the mechanization, but the main principle is that, yes, we are not disclosing the identity of the victims and also the defendants. What does identity means? Again, that depends on the opening government on how they mechanize and explain what does identity entails. Does that answer your question?
Okay, thank you.
Is there any other question? Going once?
I have a question.
Okie doke.
Okay, so the motion states that this House prefers trials where victims and defendants are anonymous. Does this mean that the government side will argue that this should be the system that is used in a certain government, or is it just like, okay, we as the government side prefers that this kind of trial happen, but if other kinds exist, that's okay too. But we just prefer this type. Like, where do we draw the line?
Okay, I don't know how much further that I can analyze, that I can answer, but either of scenarios can be acceptable, if you get what I mean. Government can take the stance in saying that we should always do this, but opening government, the government team can also, discuss that they would choose this. But so both are equally acceptable. It depends on the strategy. It depends on the how government team would like to enter the debate. Does that answer your question?
Yeah. Thank you.
Any other question? Going once? Going twice? Going 3 times? I see no other question. Good luck for the semifinal round, semifinalists.
Here.
Opening opposition?
Yes, we are here. Complete.
Closing government?
We are complete.
Closing opposition?
Complete.
We are complete.
Okay. Judge roll call. Dio, are you here?
Yes, yes.
Okay. Welcome to the semifinal round. Before we start the debate, please open your cam during your speech unless you have any kind of technical problem or signal problem. Do a check sounds before you start your speech and also mention your POI preferences. For the other speaker, please respect the POI preferences and don't forget to time yourself. Without further ado, please welcome Prime Minister to open the debate. Here.
Wait, yeah. My camera is. Wait. Okay. If you have any POI, please just unmute yourself. Sorry, suaranya bergema ya? Ada yang unmute?
It's clear.
Enggak, I'm sorry, Judge. Can you mute because it's
Sure.
echoing in me. Thank you for understanding. Okay. Starting my speech in 3. Wait. In 3, 2, 1. Okay, so panels, let's analyze why we should be defending the motion that this House prefers trials where victims and defendants are anonymous, right? So what is happening right now in the justice system right now is, even though like we are striving for a world we have a better justice system where everyone is guaranteed like equal protection and equal power, equal accountability, but the fact is still that we live in a world where these things there's still injustices, right? So we say that the idea where we can bring this motion, where we can create a world wherein the victims and defendants are anonymous, we say that we'll create a better justice system, right? So that is our stance in this debate. Because like the status quo factor maybe more is like when it comes to factors like race or religion, there's like more and more external factors that is affecting it, and thus we say that anonymity is best. So now let's mechanize on how our world of ours will take place, right? So first, like let's analyze the process of trial, right? So usually trials consists of like cross-examinations and fact-checking, and then there's deliberation from the trial, right? So what we want during these processes are like during cross-examinations, like the victims and defendants will not face-to-face, right? They will be totally anonymous. But what we also want is like they be totally anonymous in like the entire trial. So the fact that like the plaintiffs and the lawyers and jury judge will be able to like obtain information from them, but in like an anonymous manner, right? So through voice recording or what. We don't want them to know their identity like immediately because of the reasons that we'll explain later. So with the mechanizations, let's move on to the substantive of our speech. So what I will bring today is like how will it create a more just system, and what my DPM will create is like how it will be a more safe environment, right? That is safe from the external factors that I may be explaining also in my speech. So now let's talk about how it creates a more just system. So as I have characterized before, like a just system is like a world where it's a system where like these trials occur and it gives like total accountability and like power of responsibility to the victims and defendants, right? If they are actually guilty, and give the proper compensation and remuneration to the victims that are taking place, whether through form of compensation or punishment or for the defendants. Like, but what is influencing a lot of this decision making that is just is like the external influence, right? So first, I will like be splitting this into two parts. So regarding like usually the higher more controversial cases, so there's like things like race in like being in the US or religion in Indonesia. So it's like something that is constantly being talked about, because like maybe we're talking about a minority who is being convicted for blasphemy charge in here. Like maybe if people like don't know what is like these people who conduct the blasphemy charge, like is either he's a Muslim or he's a minority, then maybe there will be like more even less. There will be less split, because like when people know the identity, the prejudice of them is kicking in, right? So like even we say that the trials and the jury and the judge should be like neutral, but even this identity is like still not unprotected. But even in the U.S. Supreme Court, like one of the problems is like identity, right? Because they are not sure if this judge is not equal enough, then it will not be fair enough for the court. Because like, and then let's talk about the idea that like these defendants are also like someone that is politically important. Then this also takes account, right? Because if you know that someone is like important, and your job is like maybe contingent on them, even though, to be fair, like the justice and the other departments are supposed to be separate, but the fact is that we live in a world that is not perfect, and there's still lots of connections and favors. So this is like something that we want to avoid, right? And like even in the more general cases, like we don't want to be overly specific on the idea that we only tackle these big charges. And like we want to talk about the general cases, like maybe in an assault charge or assault charge would be a good example. So it'd like still be better for the defendants to usually have because like these defendants that usually have like assaulted a victim, like, or maybe they just crime toward the victim, like they done so from a position of power, right? Whether it's like an abusive husband or abusive employer that is like doing like systematic injustice, like sexual harassment in your office. Like this is something that they have the power to intimidate and like control over like the victims. So my deputy will maybe later talking about the fact that they may be like living in threats and like the fear that they traumatize, but also what I'll be talking about most importantly is like how they have the leverage, right? Even if like in the companies they usually have like teams that have like made these complicated clauses that are designed to prevent their employees to go against them. But like what if like this employee that is charging is not an employee that is given this crappy substandard contracts that are usually given to the bottom left, right? What if like it's something found from manager, right? The company will never know. This is why why it's important, because like it removes like their idea of the leverage of the power that they have toward defendants. But most important, secondly, is like this also like prevents in like the idea of sexual harassment in the cases. Like this prevents from these people to be targeted, like to be like harassed and bullied by like the systematic oppressors in the workplace, because like these things usually doesn't happen only like from a person to like another, right? This person used to have like lots of friends in that company, and this company is like what is causing these people to be like under pressure, right? Like an example is like the Fox News sexual harassment scandal. This is like something that is, even though only 3% is convicted, but it's like the entire corporation is like guilty to make those people that harassed to eventually leave the company, right? And this is why like we say that justice is more neutral, because like when these factors are like out of the picture in this debate, in this context, then it will be better for these trials to eventually occur, because like the considerations of other factors will eventually harm the integrity of the court. And while we do say that these defense mechanisms that are already existing to protect the integrity do already exist, it can still do fail, right? Especially in countries where like the corruption and the separation of powers is still very unclear and it's like very strong. Thus, even though like if we create a precedent in which like a world where all the trials are done in an anonymous manner, then even like if it's already a precedent, right, then even the less smaller countries and the more problematic will still follow this precedent, right? Because it's already the standard of the courting world. This is why like we're proud to propose. Thank you.
Okay, thank you very much. Prime Minister spoke for 7 minutes 2 seconds to respond to the case. Please welcome leader opposition. Hello.
Hello. First of all, am I audible?
Yes.
Okay, thank you. So I'm gonna start my speech in 3, 2, 1. Hello everyone, I'm the first speaker of the opening opposition, and I would like to say that I don't agree with the government stating that the victims and defendants are anonymous. First, let me tell you the definition about the two. Victims is a person who is harmed or injured from a crime or accident or anything in general. And a defendant is a person accused of committing a crime. Why do I oppose to the government? Because first, I want this to not be to be anonymous because they deserve to know each other, to know who they are talking about. It's their right. You know that in Indonesia, money can buy everything. So what will happen if it turns out one of them are not telling the truth? Second, I do know for a fact that in Indonesia, they allow children or sexual harassment cases to be anonymous. And I think that already done the part. By doing this, what happened is all victims of sexual harassment and children are granted anonymous for life the moment they start talking. By doing this, making our trial unanonymous, we will be different than the other country, and it will be hard for us if we have an international cases. We have been doing the normal trial for ages. I don't know why this has to be changed. Imagine this: if we keep the defendant anonymous, it will be hard for us, like for a company who is looking for someone to fill the job. What will happen if they recruit them and they won't know the crime that they have done in their life? So we don't have anything, so we can help someone if that already happened. It will be hard for the community to know what they have done. If they have done a sexual harassment, what will happen if the defendant did a sexual harassment? What will happen if he marries someone again? We will make the same mistake twice when it can be avoided. I mean, imagine if you have a boyfriend or a girlfriend who you don't know what their background. What will happen if you marry someone who have a crime, who already did a crime, and it's hard, and the crime is something like sexual harassment? It will be your life that will be taken. How about pedophile? If we make them anonymous too, imagine you are a parent and then someone applied a job to the school that your children gone to. And your children will have to face the same mistake when it could be avoided at the first place. I mean, the government have to imagine something like this would happen again and again if the defendant are being anonymous for life. It can make our life damage. Thank you.
Okay, thank you very much. LO spoke for 3 minutes, 10 seconds to respond to the case. Please welcome Deputy Prime Minister.
Hello, am I audible?
Yes, you're audible.
Okay, so my name is Hanasti and my preferred POI is through chat. Let me set my timer first. Okay, I will start my speech in 3, 2, 1. So panels, as have been explained by my Prime Minister earlier, that we believe the trials in our world will be better. And before I get into my arguments, I want to say some of my rebuttals to the leader of the opposition. So we've noticed that the leader of opposition have said that the victims and the defendants needs to know each other, and it will be different, and it will be difficult in international cases. First, the leader of opposition didn't say what is the urgency for them to know each other, like what does the input it gave to the fairness of the trial itself. And the statement that it will be more hard to the international cases is wrong. And why is it wrong? And I will explain it later by the examples on my arguments later. And the second of all, the leader of opposition also mentioned that the crime records would help the victims and the defendants on their future selves, which is not true. Which is not really true, because their crime record will only brings bad publicity and personal branding to the victims or the defendant itself. Sure, the leader of opposition have made an example out of the sexual harassment cases, but what if the cases is just as small cases, and we can't really judge people by just one mistake and one crime that they did. and we have to look on it in an objective way. What if they did the crime where they have to? Well, in some cases we cannot really justify what they do, but we can't really just judge people for just one crime that they did. Even moreover, if it's just a really small crime and they deserve the second chance, so it doesn't justify the crime record to judge someone for their future benefits. And the leader of opposition also mentioned that what about the sexual harassment defenders? What it will harm us, and the animosity of the crime, where they basically said that they are afraid that the pedophiles wouldn't be identified. That is not our responsibility. It's responsible for the law that is applied to the defenders of the sexual harassment itself. So moving on to my arguments in why our trial will be better. So as my PM have said, my PM have elaborated on what the mechanism that we will use, and he also said he also have mentioned the bad publicity and also the social pressure that victims get if the data is shown publicly and everyone knows the identity of the victims and the defendant itself, and also mentioned how the anonymity of data creates a fair judgment. So in my case, let's see a little bit more detail and deeper and comparing by the real cases that is happening in this world. So panels, the mechanization that PM have said, we believe that will bring a fair justice in our stances by few effects. So the first one I want to say through the safety of the victims. So we believe that the most vulnerable actors of the trials are the victims. And in some or so many cases, the victims are not always in the status of power, in the status of that they can recover themselves from the crimes that for the tragedy that happens to them. So many cases in the trial where victims often get hurt trying to sue the powerful defendant. Take for the real examples, and we're trying to compare here the mafia cases of Tommaso Buscetta in Italia. So Tommaso Buscetta is a very known and a big mafia on his days. Tommaso managed to finally surrender himself and managed to capture 300 other mafias and still safe until now because of the anonymity of the service earlier. You can search this later. Tommaso Buscetta family is all safe, but the Tommaso Buscetta himself is not safe. Tommaso wouldn't, but panels realized that if we could apply this system earlier, Tommaso wouldn't be in danger right now, and his family wouldn't have to hide until now, and they can be free of their identity itself. So let's talk about the other victims, the other effects. Security of the victims on a whole, like the mafia cases that I have said earlier. And the second one, the trauma, the sexual harassment cases, like the sexual abuse and everything. For the victim, maybe the defendant is also bad, but for the victims, it will create a bad stigma, especially for the woman. I'm not saying only the woman, but also men also get sexual harassed, and they also get a bad publicity in it and bad personal branding on it. And it's just a matter of how people will see it. Of course, they are the victim, but it's no secret to us. It's no secret to our society just how the people seeing the victims of the sexual harassment itself until now. It still brings more harm to them by showcasing their data. And also the second of my argument is that for the defendants, like I said before, that the defendants, there's a whole range of spectrums of crimes. And what about the defendants that did not do some major crimes, that they deserve a second chance? And by disclosing their crimes into their record, we'll only just create a bad example for them and not giving them a second chance, even though their crimes is not that big. So that's why we expected that. We believe in our world the trials will be so much better and so much fair and could by the reasons that I have stated before. And for this reason, we're proud to propose.
Okay, thank you very much. Deputy Prime Minister spoke for 6 minutes 6 seconds. To close the debate and opening half, please welcome DLO.
now I'm talking of and the opening opposition. First, I want to rebuttal the government. What the government talked about just now is about the protection of the victims, not about the status the victims are anonymous. Anonymous status doesn't always get the protection, but if you are not anonymous, it is certain to get protection from the authorities. Why we don't agree that the victim and the defendant should be anonymous? Because we need to look at the background of the parties, of the both of parties. The victim needs to be seen of his life history, such as disease history, traumatic history, and the background of his life. For the defendant, we should also look at his background. We know that in court, not all of the defendants are honest and open. We fear that the defendants are from the people who have been the present many times and also the same person in other case. The identity of the victim also needs to be known so as not to be misused by someone who should not be a victim and take advantage of that. We give advice for the government. If the government continues to impose its will on this matter, on this motion, we need what is called legal and physical protection rights. Because if the victim and the defendant remain anonymous, then if something untoward happens to the community, it can be hurt both of them. For the defendant, I strongly disagree about the government. There are so many unsolved cases that even seem to be lost on purpose due to an anonymous defendant. The defendant's position is wrong, very, very wrong. It will boomerang for the government because of the status for the defendant is anonymous. It means boomerang here. It means that I give you an example. If the defendant is anonymous, then he can do something or do same thing or even a new but heavier one. Another example in a case such as in the case of harassment. If the defendant is anonymous, then the public cannot know if the defendant repeats the same mistake. And also to avoid victim blaming and the playing victim. And that's just for me. Thank you.
Okay, thank you very much. DLO spoke for 2 minutes 47 seconds. To open the debate and closing off, please welcome government member.
Okay, I'll start.
CG?
Yes. Sorry, am I audible?
Yeah, can you speak loud? Yes, you're audible.
Okay, I'll start my timer in 3, 2, 1. Okay, so good evening, ladies and gentlemen. So I'm here as the first speaker of the closing government with our stance that we believe that this House prefers trials where victims and defendants are anonymous. So I'd like to get into our arguments. Firstly, which is what differentiates us from the opening government is that some criminals want power and fame. They get off on the knowledge that everybody in the world will know their name. By doing their crime and by going to the trial, everybody will know their name because of maybe how bizarre their cases are. And they get off on doing that, even maybe sometimes more than they enjoy their crimes. And by this case, we can see that this will hurt the victim more because it puts more attention on the criminal rather than the victim. And so we deflect attention from the victim and instead we pay more attention to the criminals. And so that's one of the reasons why we believe that we prefer trials where victims and defendants are anonymous. But also, other reasons are first, as have said before, safety for the victims and also the defendants, where victims in, for example, sexual harassment cases, we have to protect their reputation, because what if they have been sexually harassed, then the fact of that that will leak out to the public, it may hurt their reputation even more, and they may get bullied. And that is why we need to protect the identity of the victims. And also, for the defendants, we cannot yet prove that he is 100% wrong, that he is he is the one who commits the crime. And so therefore we must also protect the identity of the defendants first. And next is also that we have to remove bias, because as we know, as humans, we always have a bias, even it is conscious or it is unconscious. So in trials, there are some trials where we have juries or only judges, and we have to remove that bias, because even if the judge do try to be equal and fair, but as I've said before, every human still has a bias. And also for the jury, they may already, even though juries are expected not to know anything about the case first, but they may still, for example, they may hear about something about the case or about the person, and it can affect the outcome of a trial. And then another example that I want to give is, for example, with famous people, where we see that a lot of colored people are more commonly found guilty and put in jail. And that is because the judges or the jury know about the identity of the defendants. And so that's why it's important that the identities of the victims and defendants are kept anonymous. Maybe that's all for me. Thank you.
Okay, thank you very much. Government member spoke for 4 minutes 2 seconds. To respond to the case, please welcome opposition member.
Thanks for having me, Judge. My name is Haga, and I would like to step. I will begin my speech in 3, 2, 1. First, I would like to say that my stance in this motion is I'm opposing of the proposed system, and the reason is because if we look at the argument from the speaker before me, is some criminals do crime to be infamous. Yes, that is true, but some actually a lot, according to Panama Papers, don't want to be known that they are doing the crime that they do. And also, I also hear that this will protect the victim reputations. Yes, but also the sexual harasser will be protected, and that is actually my main point today. Is when the speaker before me, I think it's the OO, said that the victim isn't in the position of power. I agree. The victim is not in the position of power, and this anonymous system doesn't help because it's also offering protection to the offender. As someone have said before, that this protects the harasser to not be known in the public to be the harasser, and even some part of the system already been exploited, especially by big corporations. I would like to cite an example of Stephen Donziger case with Chevron, in which the corporation of Chevron, in which Stephen Donziger successfully, is an environmental lawyer, successfully sue and win money for the people of Colombia because Chevron make their river polluted, and Chevron doesn't like this. And what Chevron do is Chevron put a defamation sue against Stephen Donziger anonymously, uh, anonymously because as a civil law and it in the US, uh, and the Chevron use this defamation suit to ruin Stephen Donzinger's life. And when they can't, they use other people to be anonymous to do their bidding. So the system of anonymity could, if there is a system of anonymity, we would not know that the trail of money that Chevron gives to some of these people to ruin these people that Chevron doesn't like, basically, can be protected and even reinforced because one party that will benefit really hugely about this is party that has a lot of money to know the informations that the other party with less money doesn't know, and in this case is the identity of either the victim or the accuser, like Stephen Donzinger case. I think that is all that I could say. Thank you.
Okay, thank you very much. Opposition member spoke for 3 minutes 24 seconds. To respond the case, please welcome government whip.
So hello everybody. My name is Advita as closing government. So first of all, I would like to restate my claims that this house prefers trials where victims and defendants are anonymous. So why do we prefer? So first, because of safety, and then also removal of bias, and also decrease of stress and prevent more traumas. And also, I would like to bring up a case where, for example, there's a sexual assault, where sometimes the identity of the person being assaulted, they prefer their identity to be disclosed and not brought up. Why? Because, first of all, many cases where the victims they have lower power, and so sometimes they're afraid that their case won't be further seen, and so they prefer to be disclosed. And also sometimes the victims are also ashamed. Maybe they're afraid that by having their identity shown to others, that others may judge them. For example, think that it's because of how they probably how they dress and how they act that make them becoming a rape victim, for example. And also, many before me, many have argued that if the defendants are anonymous, then they might perform more crimes because others may not be able to know their identity. But I don't think that's right, because our point in this debate is about the anonymous defendants during trial. But after the trial, if they are proven to be wrong, then in most cases their identity will be shown, and so people would eventually know their deeds and would be aware of what they have done. And so I would just like to say that also previous oppositions have said that what if we don't know the defendant, and what if we marry the defendant who have assaulted other people? Well, before you marry somebody, don't you think you want to get to know the person you're going to marry and learn more about them? I think that argument isn't right, because before you marry someone you love, marrying means spending the rest of your life with the person you love, it means you have to know them, get to know them more, and you'll probably learn about their past also. And so I would just like to repeat my friend's statements that are arguments of why we prefer trials where victims and defendants are anonymous. First, safety for the victims and defendants. So, why do we need safety for victims and defendants? Because victims, we want to protect their reputation. Because, for example, my sexual assault case before, and for the defendants, it's because we don't really know yet if the defendants have done anything wrong or if he's just falsely accused. So we have to keep their identity closed. And then also to remove bias. Why? Because if nobody know who the person is, and so in which nobody knows the identity of the person during trial, and so the judge wouldn't know. Sometimes the judge may have like a connection already beforehand with one of the, let's say, defendant or the victims. They might favor one over the other, and so the trial won't be fair. And also, if the victims are not known, it also decrease their stress and prevent traumas. Because if they're known, then again, I repeat my statement before, they could be judged wrongly by others also. And also the point that criminals sometimes also also cause chaos and make crimes because they want fame. They want people to know them, so they try to create issues and try to make crimes. I think that's it from me. Thank you.
Okay, thank you very much. Government Whip spoke for 5 minutes 28 seconds to close the entire debate. Please welcome Opposition Whip.
Good afternoon, Judge. Am I audible?
Yes, you're audible.
I'll start my speech in 3, 2, 1. Now, the thing about court is it's important for transparency to be respected in court. So let's take the example of a defendant being falsely accused. I believe that it's the right of the defendant to know who he's being accused by if he's falsely accused. Right? And in the case of the victim, you said it was for their safety. Right? Well, to me, anonymity doesn't really help them because I doubt that the assaulter or the offender wouldn't know the identity of the victim, so it doesn't really help in that safety regards. But also, by making it publicly known, like my friend stated, the government, the law could offer them protection, and then the community could also offer them safety. And also, there's also the argument about the offender always being in a higher position of power. Now, by giving them anonymity, you're hiding them in a veil, which makes it easier for them to shift the advantage to them. Because the thing is about unfairness in court is that usually it could be investigated and it can be found out. But by you making it so that the identity of the offender is anonymous, it makes it much more complicated. And second of all, for the proceeding of the court, as the opening government has stated, there's the part of cross-examination where the victim or defendant can be called up to be interrogated. And the thing about that is, if their statement contradicts the evidence, it could basically prove their guilt. So by having it so that they have to show up and give their statement in person and not being hidden, it doesn't really give them a chance to fabricate their story. So it's easier to catch them if they're giving false statements. And then in the case of it being an old case that the new evidence have been resurfaced, it's easier for you to keep track and records of past crimes if it's not being hidden by anonymity, because you can easily find out that something didn't really click right because something was missing, and then you found that evidence years later. You can dig up the case easier and quicker, and then you can go back to the case and prove their innocence. And then there's also the case of international laws. If we have a country which has the anonymity kind of system, and then another country that doesn't, it could really prolong, like it could delay the entire system of the trial. And also, I believe that the public should have the right to know if someone did something wrong. And you said that they should have a second chance. Yes, they should have a second chance, but that doesn't mean that they shouldn't be marked for what they have done. They should have a sort of punishment for their wrongdoings, even if it's a moment of or a lapse of judgment in their half. That is all for the argument. Thank you.
Okay, thank you very much for the speech. That's all for the debate. This is a silent round. You can go back to the main hall while the judge will discuss on the ranking. Thank you. Good luck for the grand final.
Thank you, everyone.
Thank you.